Welcome. For those of you who have been with us for the past 5 annual judicial panels, welcome back. For those of you who are new to the judicial panel, thanks for joining us. We're going to take a different twist on the judicial panel this year, as if you've read the description, you know that we're going to be expanding it a little bit. You're going to be here for 3.5 action-packed, chock-full of nuts days of e-discovery. And don't get me wrong, we're still going to cover e-discovery in the judicial panel, but we live in interesting times, and there are issues that affect us from the courts and the law that go far beyond e-discovery. So we wanted to broaden our perspective a little bit, and we've done that today. With any conference, there are always the technical issues and snafus that come up. No more so than what I found out this morning. I looked at the sports reports, and my explanation was, you have got to be expletive kidding me. I want to personally thank each and every one of you who is not out watching the Cubs and the Brewers in a do-or-die playoff game. But if you saw a tweet I sent out, I promised you would have live updates, and we will keep our word. At the moment, it is top of the 4th. Brewers 1, Cubs 0. And for the Chicago faithful, I hate to break it to you, but right now the Brewers have a no-hitter going. But you're here for some law, you're here for some tech, and we'll also give you some baseball. But most importantly, my bio's up there. You did not come to hear me. You've come to hear 4 of the outstanding judges from across the nation who have really been very great to us and taken some time out to share their expertise with us. Please join me in welcoming Judge Fisher, Justice Kennedy, I should say, Judge Peck, and Judge Rodriguez. 3 of our 4 judges have been with us for all of the years of the judicial panel. And we start off with, of course, the Honorable Nora Berry Fisher, United States District Judge for the Western District of Pennsylvania. As we've told you before, Judge Fisher's career is something near and dear to my heart because we both have been legal editors. Not only that, Judge Fisher has been instrumental in the Special Masters program in the Western District of Pennsylvania. That is Pittsburgh for all you Steelers fans out there. In addition to that, she served as president of the American Academy of Trial Lawyers, and she's a member of the American College of Trial Lawyers. Please join me in welcoming the Honorable Nora Berry Fisher. Next is our newest member of the judicial panel, and most of you probably figured this out. All of our judges are very preeminent, and they are always listed and seated in alphabetical order. Justice Tanya Kennedy is a new addition to the panel. She's the first time that we have had a state court justice. I think if you've come to the judicial panel over the years, we've talked about the changes to the federal rules of civil procedure, the federal rules of evidence. You get a theme going on here. It's federal, federal, federal. When in reality, when most of you are working during the day, a lot of you are working in state court matters. So Justice Kennedy is a welcome addition, giving us that state court perspective. Not only is she Supreme Court Justice in New York County and the New York State court system, she is also the president of the National Association of Women Judges. Please join us in welcoming the Honorable Justice Kennedy.
Thank you.
And next, if you did take time to speed through my bio slide, the most important part of it is, of course, is I have the high honor and privilege of working with a lot of great people at Relativity to produce the Uncivil Procedure podcast. Within the last hour or so, the latest episode has been released. Please find it on your favorite podcast vehicle, whether it's Apple, Simplecast, whatever you use, because our next judge, someone who needs no introduction, is the guest in the latest episode of Uncivil Procedure. In addition to being our guest on the podcast, he is also senior counsel at DLA Piper, and for many years was U.S. Magistrate Judge for the Southern District of New York. And I can't resist, I'm sorry, Your Honor. Also, to many of you and to all of us, the grand poobah of technology-assisted review, the Honorable Andrew Peck. And finally, U.S. District Judge Xavier Rodriguez from the Western District of Texas. Judge Rodriguez brings I was wrong there. I say that we haven't had a state court judge or justice. We haven't had a sitting state court judge or justice, because Judge Rodriguez, before ascending to the bench as a federal district judge, was a Supreme Court judge on the Texas Supreme Court, Justice, I should say. Judge Rodriguez obviously is an e-discovery expert. He not only sits on the Western District of Texas, he is also an adjunct professor of law teaching e-discovery law at the St. Mary's University School of Law in San Antonio. Please join us in welcoming, once again, Judge Xavier Rodriguez. What we decided to do this year, we mentioned that we're going to expand our horizons beyond just e-discovery this year. And you've got a list of cases we're going to discuss today, and here are some of the topics. You'll see international e-discovery. And when I set this out, I compiled a veritable cornucopia of cases that I thought might interest the judges. They chose a grand total of 1. And that's Carpenter v. United States. You're going to hear a lot about that. That's a Supreme Court case, and Judge Fisher will be leading us in that case at the end of the hour. We're going to start off with ex parte application of Levi Strauss & Company. Judge Peck is going to take us on an international tour on that case. We're then going to expand beyond data law or data discovery with diversity and inclusion in the courts and the profession. And Justice Kennedy selected SEC v. Adams, a really important case on diversity in the courts and the law. And then you can't have a tech conference without some sort of artificial intelligence. And that is why Judge Rodriguez is going to help us with Waymo v. Uber. I am sure that you've heard about the self-driving car dispute between these two companies, and it goes on beyond that. It turned into a discovery dispute. So we'll have fun getting into that as well. Let's start off with Levi's. I personally had no idea that there was so much litigation over Levi's. How many of you in the audience have ever worn a pair of Levi's jeans? Most everyone in this room has been a potential subject of trademark litigation. If you look at what you see on the screen, you see the tab, trademark litigation over that. You see the arcs on the pocket, trademark litigation over that. Even the patch, you're going to see in that photo on the slide, a real and a fake Levi Strauss patch. Trademark claims on all of these things, and and it's a new trademark issue for me. I had never heard of the curve-shaped bow. I'd seen it, just never paid attention. Judge Peck, there's the Wayback Machine. What in the world do the Wayback Machine of the Internet Archive, Levi's tabs, Levi's stitching have to do with data law?
All right, well, I'll note when we were talking last night, I asked semi-seriously, should I wear my Levi's instead of a suit for the judges panel? And I decided that if I had to turn around to show the trademarks, not my best side, shall we say. I'm not sure that I have a best side even from the front, but nevertheless. All right, so here's what happened in this case. A little bit of background. As you saw the fake Levi's patch, Levi's is very protective of its trademarks, and it sued a company called The New Yorker, which was a European company selling knockoff Levi's. Sued in courts in Germany, won a judgment and a cease and desist and a settlement. There was then a subsequent breach and further settlement. Then, the New Yorker did not learn its lesson. There was the third breach and a suit in Holland over it. Now, as you all know from all the cross-border discovery discussions we've had, other than the UK and Ireland, they don't have discovery the way we do over there. So the question was, how many fake jeans did that company, The New Yorker, sell? And Levi's could not get enough information from that company in Europe, and so it came to the United States. Not that The New Yorker is located here, but it was trying to get information about the number of different designs of fake Levi's. And the way it did it was to try to look at the New Yorker's website over the period at issue. Unfortunately for them, the New Yorker spoliated, but they don't have the tort of spoliation, and its website was cleaned up before Levi's could do anything about it. So it came to the US, and in the sort of flip of US people can't do discovery in Europe without all the implications from the GDPR, we have a statute, 28 US Code 1782, which I am surprised is not used more than it is, that allows a party with a European lawsuit, arbitration, or similar proceeding to get discovery in the United States, whether from a party to that lawsuit or anyone else. You can get documents and ESI through a 1782 application, and you can get discovery. Now, what they did, and of course the test, as you see on the screen, whether there is indeed a foreign proceeding, the nature of it, whether you're trying to circumvent foreign law, sort of the flip of GDPR issues, and then whether the request is unduly intrusive or burdensome, which brings in all the federal rules of civil procedure proportionality issues as well. Now, the person or entity that Levi's wanted information from was the Internet Archive, which is also affectionately known as the Wayback Machine. Those of you of a certain age will remember the Rocky and Bullwinkle Saturday morning cartoon shows. You know, Rocky the Flying Squirrel and Bullwinkle, his Dr. Watson-like assistant, friend, whatever.
Sir, you know that was our bulwark effort against communism.
Well, yes, there was Boris Badenoch and Natasha something or other as the criminals, spies on that. But they also had a segment with Mr. Peabody and Sherman. And I guess we should have put a picture up of Mr. Peabody and Sherman. Mr. Peabody was this dog in basically a suit and very respectful, and Sherman was the boy. If you just heard the names, you would have thought it was the other way around. And they used a Wayback Machine, a time machine, in order to go back in history and give history lessons to the kids watching the show. The Internet Archive purposely took that name, and yes, you can find that in their FAQ as an homage to Rocky and Bullwinkle. But what the Wayback Machine is, and one of the reasons we picked this case, is so you can use it in your litigation and preparation, is it for the last 20 years has every day surfed the web and copied websites. So that you can go back and see what was on the New York Times website 10 years ago on a particular day and time, if that was one of the webs that they surfed and recorded that day. So what Levi's was doing here, and you could publicly access it, it's archive.org. But what had happened was the New Yorker's website had once been on the Wayback Machine and wasn't anymore. So Levi's filed a 1782 ex parte application in order to find out from the Wayback Machine whether the New Yorker had asked for its websites to be deleted, which would be further evidence of its bad faith for the European litigation, and if so, whether, and the Internet Archive honors requests from website holders to delete their websites. But whether it's deleted from public view does not necessarily mean it would be deleted from the Internet Archive's archive. So they were trying to find out whether there had been a request to delete, and if so, or even if not, whether there was any way from behind the scenes they could get access to that website.
Judge, question for you on this, and actually anyone who'd like to jump in on this. Tomorrow morning at 8:30, we're going to have the international panel where Chris Dale of the E-Disclosure Information Project is going to have a great panel with Airbus, McCann Fitzgerald, EY, Grant Thornton, and they're all going to be talking about the international issues these companies face. We talk about in Section 1782, it's to encourage other countries to show the same sort of deference to our courts. One thing they're going to talk about is the Cloud Act tomorrow and these executive agreements. Under the Cloud Act, it seems dubious whether people are going to play in our sandbox anytime soon. Do you think that 1872 is really going to inspire other nations to play with us here?
I think it'll be a game changer because this statute has been around since 1948. So the short answer is no, not likely. That was an intent of it when it was enacted to encourage cross-border cooperation. I don't see that this is going to change the problems we have under the GDPR, Brazilian data privacy, APAC privacy statutes. We still have to thread that needle using the devices that are available, and particularly under the GDPR, it is now a little easier to get information from abroad into the United States under one of the derogations, as they call it, or exceptions, that allows for transfer for litigation purposes, in essence. But this is not really going to impact that in any way, in my opinion.
Thanks, Your Honor. We're going to be moving now from Levi's across the globe to the pine forests of Mississippi, and it brings us to Ponzi schemes and pine trees. And this is SEC v. Adams. This is a case that Justice Kennedy selected, as we mentioned. Basically, we've had far too many Ponzi schemes, and this one involved investments in land in Mississippi. Where this becomes an issue for us is how a judicial officer was going to be selected. And Justice Kennedy, can you pick up the story from there?
I sure can. First, I want to preface my statements by saying that my statements do not represent the National Association of Women Judges, nor do my statements represent the unified court system of the state of New York. And I want to thank David and the Relativity staff, and also my colleagues, just for their warm welcome. And it's such a pleasure to be here today. This is a short decision, 7 pages, that sets forth the selection process for court-appointed receivers. And this case came to my attention, and it's now a little plug for my organization, NAWJ. It came across my attention because one of our fellow members sent it to congratulate 3 members. Their work was cited in this opinion. Professor Judith Resnick from Yale Law School, Professor Vicki Jackson from Harvard Law School, and also Lynn Heck-Shafran, who is a New Yorker. I'm from New York. And all 3 women are really trailblazers with respect to their work regarding gender imbalance in the courts, and also the fight for equal equality for both men and women, but particularly women. And after we learned of this case, I was invited to a conference where this case was also discussed. And Judge Reeves really speaks truth to power when we discuss the lack of diversity in the legal profession. And it's my opinion that I think this cuts across all sectors when we're talking about women, when we're talking about persons of color and the lack of opportunities that they have. And very often, it is because, as Judge Reeves points out, systemic discrimination and systemic exclusion to be invited to the table. And as I said last night to my colleagues during dinner, all of us, we have a responsibility to increase the pipeline. As I sit here today, I am a product of the pipeline. Why do I say that? I say that because someone saw something in me, saw my potential, and certainly gave me the opportunity to prove that I was qualified and up to the task. Certainly, in spite of the fact that women now outnumber men in law schools, certainly that isn't reflected in the judiciary. It isn't reflected in the legal profession as we're talking about female partners, and this is a tangent. It applies not only to the legal profession, but I think corporate America as well. When we're talking about ability and also showing initiative, many times when women are evaluated, they are evaluated on their experience, whereas men, what is their potential? We need to shift the paradigm. We need to change the way of thinking, that also it's about capacity, knocking down these myths that apply not only to women, but to people of color, that we can't find any qualified applicants. My question is, are you going to the particular organizations? Are you going to the sources to obtain qualified applicants? Certainly another myth, and I'm sure my colleague will agree, women are not assertive. We are. We are. I think the same thing can be said for people of color. And another myth is that, you know, we are fearful. No, we're not. So we need men and women, white persons, persons of color, to come together, because I really think this says it all. And I'm going to read from the case, and I'm going to paraphrase. Some steps have been taken to remove these stains. Still, when given the opportunity, courts should take steps to increase their diversity. Justice is a search for truth. Let me repeat that, because I wholeheartedly agree. Justice is a search for truth. That search will fail if a court does not incorporate a wide array of experiences, facts, and perspectives into its decision-making processes. The case for diversity is especially compelling for the judiciary. As District Judge Edward M. Chin has said, how can the public have confidence and trust in such an institution if it is segregated, if the communities it is supposed to protect are excluded from its ranks? To deliver justice and ensure its legitimacy, then the judiciary must diversify itself. And I take a broader viewpoint of diversity. It's not just about women, not just about persons of color. It's about sexual identity, sexual orientation, economic backgrounds, culture, region, and experiences. Once we have this, that is when we can really have true justice. The search for truth, the search for justice.
Justice Kennedy, are you at all optimistic? When we were deciding which data to put on the deck, we discussed it, and it's no coincidence that the data from the University of California at Berkeley is here, because that's over 60% of the class are female. And it's not just Berkeley, women are a majority of law schools now. Are you optimistic? Do you see things changing?
I am optimistic. I always say that the glass is half full as opposed to empty. But also, we also have to take action. So taking action is ensuring the pipeline. And we do that by forming strategic partnerships with concerned individuals like yourself to build alliances, create opportunities for all of the groups that I indicated. And this is a very difficult subject. There are some people, when you say diversity, they sort of cringe because they just focus on race. And it's not about race. It's about all of the things that I have just outlined. But we have to have stakeholders, important stakeholders who will certainly buy in. And that's leaders at the top. And I'm certainly not afraid to lend my voice, to speak truth to power, and certainly to outreach to the various young people, young women, and the like, to invite them to join the legal profession. That's my responsibility.
Judge Fisher, we know over the past years that you are by no means fearful at all. And in fact, in no uncertain terms last year, you told us what you might have done in the Taylor Swift case.
That's exactly right.
Over the years, how have you seen things change for women in the law?
Well, there has been gradual change, but by the same token, we have not made the kind of strides I would have thought that we would have made. And I think, and part of it, we talked last night about it, is women do leave the profession for a variety of reasons and do not continue on to partnership or law professorships or to the bench. And there are lots of reasons for that. But one of the things that we've been trying to look at in Pittsburgh through our local Academy of Trial Lawyers and also on the bench is how do we engage the younger attorneys, the more diverse attorneys, get them up on their feet in the federal district court. Because just as the justice said is, there is truth. In a diverse judiciary, there is truth in a diverse legal profession. So one of the things that we're doing is we are encouraging all of the judges in our court, in effect, to call on the younger person who might be part of a panel of lawyers appearing in front of us. I know Judge Scheindlin has done this. Yep. Judge Weinstein has done this, both in New York, and I think other judges across the country have. In addition to that, we actively serve, for example, in the Academy of Trial Lawyers on their diversity committee so that we try to bring more diverse people of all stripes to the trial bar, particularly, and encourage them and mentor them and kind of show them the way in various ways. And one of the things that we continue to hear, and I think this is where the audience can be helpful, sometimes we hear it's the client who says, we want the lead trial lawyer to make the presentation in the claims construction hearing or in the suppression argument or in the discovery motion. And to that end, we say to those clients, again, corporate America, you need to be able to put these people forward so that they can advance, so that they can learn the ropes, so that they can ultimately be the lead trial lawyer. So It's not just the judiciary's problem, it's not just the law school problem, it's also a problem vis-a-vis the legal profession as a whole, as well as law firm structures and the corporations, the clients, giving those young people, giving those more diverse people a chance. And I think that that can be done, and it can be done fairly easily.
Can I just follow up
Absolutely.
on what Judge Fisher said? Certainly there are many corporations that are requiring the law firms to have diverse persons on their team. They require it. And if they do not, they lose the business. And I'm certainly aware of some of the federal judges indicating if you have a younger person, they should be allowed to argue a portion of the motion. I know it's a bit controversial because I think some judges incorporate certain things in orders, and that's whether or not you can do that, put things in orders. I welcome that. Certainly, we don't do that in the state court. I can say if I see a woman, with 4 or 5 men, I'll say, how is she going to participate? That's how I'll handle it. But it's really up to us. We are the leaders to say, this is what we expect, and we encourage you. And certainly the New York State Bar Association, they have programs with respect to creating litigation opportunities for young female attorneys, but it's going to take all of us.
If we go back to a quote, and one of the things we talked about is that perhaps we're going to have the most provocative judicial panel yet. And one of the things that we wanted to stress is here at Relativity Fest, unlike what may be going on outside these walls, it's a place where we can exchange ideas and throw things back and forth. And if you read this quote from Judge Reeves, it's an incredibly provocative quote. And out of respect to the judges, I'm not going to ask them this question because it would put them in an indelicate spot and it just wouldn't be nice. However, I will ask you. And so in the audience, I'm wondering if you look at Judge Reeves' quote, and I get that you may not even want to raise your hand on this one. It's a delicate issue. But do you think that there is the kind of institutionalized discrimination in our courts that Judge Reeves references here? Show of hands if you feel that it's true. All right, we've got a fair number of hands that are showing that. This is tough for me, and we all have to look at our own views because had the honor of Judge Peck being at your retirement party. Justice Fisher, we've worked together on National Association of Women Judges projects. Judge Rodriguez, we've been around judges. Judge Fisher as well. These are nice people. I don't think they're...
Don't sound so surprised.
But it's hard to imagine that it's institutionalized this way, but clearly you can see...
let me respond to it this way, David. When we're talking about systemic discrimination, it really becomes a difficult issue, right? And so the background to this case, Judge Reeves was called on to appoint a receiver. And so that's the genesis of this motion. He needs to appoint a receiver in these proceedings, and so he wants to appoint a receiver who's of a diverse background, and he launches from that narrow issue into his discussion about the state of the judiciary. And it's a pipeline problem, like Justice Kennedy mentioned. There may have been in the past, and certainly, I think historically you can argue there was systemic discrimination in both the federal and state court systems for a long time. But if we're talking about present scenario right now, it's really kind of concerning to me. And so we can talk about our daily lives here in our worker world. But if we're taking this out to the broader world at large, as regular citizens, we need to be concerned about the pipeline. And what do I mean by the pipeline? For at least blacks and Hispanics, right now, graduating from high school, there has been a decline in the percentage numbers of Hispanics and blacks that are graduating from high school from when I graduated in high school. So the pipeline has a problem. And then you take that on to college now, and with the cost of colleges and universities being what they are, you have the further challenge of blacks and Hispanics being able to financially afford a 4-year institution. And then you take it one step further with law school, and so the pipeline now is not bringing in the numbers we'd like to see. And so if we're talking about systemic discrimination in that kind of a context, it's not really limited to the legal profession, and we've got some serious issues as a society to work through. Kind of interesting, I have not verified this, but I'm not sure who Judge Reeves actually appointed to be the receiver in this case, and whether he actually was able, because of the pipeline issue I've described, where they actually appointed a person of color or a woman to the position.
Judge Rodriguez, I have that answer for you, because late one night researching the epilogue to this case, he in fact appointed a Caucasian woman. Mm-hmm. And that may go to the pipeline issue you're talking about right there. Now, I'm sure a very accomplished lawyer. She was a partner at a major law firm, but that just goes to show you.
Can I say one thing?
Sure.
But I think that is a part of the pipeline, because the issue is with many court appointments in many instances can be lucrative, and it's also a feather in the cap of the attorney that receives the appointment, and it leads to other appointments. It's a mechanism for career advancement. So whether it's a person of color, whether it's a woman, it's still a pipeline issue. So I take the position that it's been satisfied, because women also are regularly excluded. Multi-district litigation, lead counsel, class actions. Women are not a part of this.
But will they
There's
be?
the phrase of the old boy network. And so women are excluded. So I think that it has been satisfied. It's not about just being black. It's about women, all of the populations that I indicated that have been underrepresented.
Judge Peck, you were going to say something?
Yeah, I'm off the bench so I can be a little more un-PC or PC, depending on which way you're looking at it. But it also depends, with federal judges. During the Obama administration, federal judges who were appointed tended to be minority, female, LGBT, et cetera, et cetera. In the current administration, most of the appointments are white males. That skews, and judges have lifetime appointments. That's going to continue the overwhelmingly white male aspect of the judiciary for a long time, hopefully until the next administration very quickly comes in and
Let the record show that Relativity takes no political position in any campaign whatsoever. And more importantly, on a lighter note, 6th inning, Cubs have tied the score. But
Go Cubbies.
moving on to issues that are not quite as weighty, but still important. We are at a legal technology conference after all. You see Waymo and Uber here. Autonomous vehicles, self-driving cars. We have now gotten into our artificial intelligence case of the judicial panel. Question for you: how many of you have used an ephemeral app, disappearing data app, as it were? Wow, surprisingly few. I guess you don't work for Uber. But that, of course, is a segue into what we're discussing. There were allegations that Waymo was purchased by our good friends at Google, of course, and there were allegations that some of the former employees went to work for Uber, and there were allegations of corporate espionage. The ephemeral disappearing app in question here is Wicker. And, of course, you see, we didn't pick these graphics just out of coincidence. On the one hand, you've got securing the world's most critical communications. Wow, that's great. But look at the other one, leave no trace. Somewhat ominous. Judge Rodriguez, what happened here?
So Google and Uber are in a race to build self-driving vehicles. And one of the lead engineers for Google, a guy named Anthony Lewandowski, was hired off by Uber. And so there's a lot of bad blood about hiring off of certain employees. And at one point, Waymo, which is the Google outfit, finds out about, perhaps they've got some stuff that doesn't belong to them and belong to us. And it's kind of curious about how they found it. One of their vendors forwarded them to an email that had a circuit board attachment and they go, hey, that looks like our circuit board. And so they start digging, and ultimately they file a suit against Uber for misappropriation of trade secrets. We have a whole bunch of discovery disputes, and I think that sets the tone for where the judge ultimately came out on this. But months before the first trial setting, Uber claimed it just discovered a trove of unproduced documents. There was about 15,000 emails and about 85 gigabytes of other documents. So there's a trial continuance. Judge is kind of a little upset about that. Waymo's requesting adverse jury instructions for all this discovery abuse allegedly that's going on. Then, all of a sudden, the U.S. Attorney's Office contacts the judge and says, hey, we've got some information here from a former Uber employee, a guy named Richard Jacobs, and he seems to have a whole bunch of information about this trade misappropriation case of yours. And so in calls the judge to all the parties and say what's going on here, and it now finds out that we've been using Wicker here. And Wicker is one of these disappearing apps here, and so the allegation is that the Uber employees are using Wicker to hide their trail. And ultimately, the judge comes down yet with another discovery ruling, and it's a long one. And it's kind of, frankly, trying to find a delicate balancing point. The judge is looking at all this discovery fights that have been going on between both sides, and it turns out, too, that the other side had been using disappearing apps, too, and so there's really not a lot of clean hands over here, and the judge is wrestling with how much does the jury get to hear about the use of this disappearing app solely as evidence that there must have been trade misappropriations going on, because we're trying to reach the merits of the case as opposed to having the jury hear about these discovery fights and get all sullied in that muck, as opposed to trying to figure out whether there indeed was misappropriation going on. And he comes up with this, you can fault it perhaps for this middle of the ground approach, and he goes, well, Waymo can mention in court that Uber used Wicker as a possible explanation for why Waymo has failed to turn up more evidence of misappropriation. It can't use that evidence, however, to invite improper speculation or vilify Uber without proving much else. And so it's kind of an unsatisfactory ending to this story. Can you or can you not use these disappearing apps? And so going back to basics on e-discovery, we all know that we have a duty to preserve data once we become aware or should become known that litigation is likely, and so that's our trigger. And so in this case, the trigger obviously occurred. We knew that there was going to be an allegation of theft, of misappropriation of trade secrets, and so should the litigation hold have been made applicable to Wicker? That's really the threshold question in this case, and I don't think this opinion really answers that threshold question. You can argue it a couple of ways. You can argue it that, hey, no, Wicker now is sort of like the modern telephone call. If we could have conferences with our fellow employees, we could just pick up the phone and talk to each other. Nothing's ever put down in writing, hence there's no need to preserve anything, and there's nothing illegal about doing that. So that's one analogy you could make to this case. I think, frankly, the better analogy, though, is this is not a telephone call. So once you have made the decision that you're going to use any kind of an app, or if we were going to talk about telephone, you made the decision you were going to record the telephone conversation, then at that point you have a duty to preserve that evidence, and in this case it should have been preserved. Disappearing apps, depending on settings, and this is where it's going to get beyond my technical knowledge, but some settings have the ability to take away the self-disappearing part of it. Some apps also allow different settings, and so you could save it for some period of time before it'll disappear. And so I think we just go back to basics. This is at least my personal opinion on these devices. If you're using a device that has the ability to set the device that it will not lose the evidence, then you can continue using that app, but you just can't have the evidence disappear. If you're using an app that doesn't have those kind of controls and it's automatically a disappearing app, I think the instructions should be given as part of the litigation hold process that you cannot use this app past this point. But that's where I sort of come down.
Judge Rodriguez, we've got a quote here from the court, and it's on the whole litigation about litigation issue. To repeat, the central issue in this case remains whether or not Uber misappropriated Waymo's trade secrets, not whether or not Uber is an evil corporation. And it's the whole litigation about litigation argument, and we take no position on whether Uber's evil. But it seems to be a central issue. When they had the federal rules amendments in 2015, it was great, we're going to have litigation about litigation, except everybody in this room is employed on litigation about litigation. Isn't it a fair question? And for instance, if I went out and I burned a bunch of paper files the night before a production deadline, that's going to raise some suspicion. Do you think going forward, if these things become ubiquitous, it's going to be like, well, everyone has disappearing apps? Or we take it on a case-by-case basis where, aha, there you go.
So, there's no standard right now, at least in the federal courts, about what's going to be a material trigger here on whether or not we're having discovery on discovery. I mean, so you can I'll take the extremes, and that's easy. It's obvious once we have the litigation hold and the material's easily discoverable, you're supposed to keep it and produce it if it's relevant and proportional, and that's the easy part of the extreme. Then the harder part of the extreme is, okay, well, what about stuff out here that's going to be difficult to get? And we go through the proportionality analysis. But these disappearing apps are a whole new animal, and what I'm afraid where we're heading with the federal rules, I'm all for proportionality, don't get me wrong, but we're almost using these federal rules now as a new vehicle for I just had a senior moment, for tort reform. We're now so concerned about the cost of all this that, oh my goodness, we should not, thank you, Craig, we should not bear any kind of difficulty in gathering this data. And, it's a false choice in my mind. If your company officials decided to use certain disappearing apps, and you can control which your employees are using, you can tell them thou shalt not use. Now, if they do use, you're going to have to enforce it with some kind of sanctions against your employees. But you're allowing that behavior to go, and you can't allow that behavior on one hand and then argue cost on this other hand. To me, those are inconsistent positions.
Judge Rodriguez, Judge Peck, before we get on to our final case of the day, has 60 seconds on what may be a rebuttal or complete concurrence in your brilliant analysis.
Concurrence, of course. Now, I was just going to say that under the Sedona Conference, Sedona Principles, Principle 6, the responding party is in the best position to decide how and what it is going to produce, and there should not be discovery about discovery unless the receiving party can show something is missing. There is a gap, there is something wrong, not just we don't trust them. On the other hand, I think we are now with many of these devices, including to a large extent text messages, where we were with email 10 years ago, which is the wink between lawyers, sort of the I won't ask you for your disappearing messaging apps or even your non-disappearing text messages as long as you don't ask me, because we are not technically able to handle it. Now, that is a mistake. Lawyers have to be able to handle it, but I think there is a lot of that going on.
And on to our final case of the day. And just to show you what an egalitarian festival Relativity Fest is, when I was asking Judge Fisher, hey, you up for another trip to the rodeo? Please come back this year. I said, yeah, and I told her about the format, and she immediately chose Carpenter, the case that you are about to see here. And I spoke to Judge Peck and mentioned that Carpenter was taken, and Judge Peck's response was, well, why does she get Carpenter? Power to the women, sir.
Okay.
Carpenter is our final case, and arguably maybe the most important because it is a U.S. Supreme Court case, and many of you may have heard about it in the news. It starts off with a Radio Shack at a T-Mobile store. Actually, many Radio Shacks and many T-Mobile stores. There were guns, there were cell phones, there's triangulation of data, and more importantly, Judge Fisher actually played a role in this case.
Well,
Your Honor.
Thank you very much. Yes, I picked this case for a number of reasons. One, I had a case in the Western District that emanated from this ring out in Michigan. Two, I've seen these kind of cell site simulators and what an FBI agent can do with that in terms of presentation at the time of a trial in a separate case. And three, when I was doing some background on this, I was impressed with the fact that Ruth Bader Ginsburg said this was the best decision of the Supreme Court this year. So what this case is about, tools of the trade. As David mentioned, they're dealing with iPhones, iPads at T-Mobile stores, Radio Shack stores, and in my case, the local AT&T store. And bottom line, these folks who were engaged in primarily drug activity wanted to use the tools of the trade, i.e. the cell phones, the iPads, of course there were guns involved as well, so that they could ultimately transport a lot of drugs. So what was happening in Michigan, Mr. Carpenter was the ringleader, and he, because he is of this day and age and he was in the drug trafficking business, of course, he used a cell phone. And as many of you know, cell phones operate by virtue of cell towers, and there's constant interaction between the phones and the towers. And in effect, it creates all kinds of data so that you can determine night and day exactly where people were. In this particular case, under an act, the Stored Communications Act, the government asked two magistrates to permit access to cell storage data. And they did it in historical fashion. They weren't just looking for a day's worth, they were looking for days and days worth, so they could track the activity of Mr. Carpenter. And so in that particular instance, the district court judge, then the Sixth Circuit, both felt that that was perfectly appropriate under prior precedent of the Supreme Court. And particularly two lines of cases that dealt in one instance with phones and phone records being public, the other one with business records like checks being public. But interestingly, when it went to the Supreme Court, Justice Roberts, writing for the majority, decided no, there was more here at stake, and that expectations of privacy were also at stake. So ultimately, the Supreme Court rules that in this type of case and going forward, rather than rely on an order from a judge based on the Stored Communications Act, which has a lesser burden, you, in these instances now, have to go before a magistrate judge with an affidavit of probable cause. And I'll just segue very quickly to this other case that I had where both the act and the probable cause affidavit were at issue. And in that particular instance, there was also a confidential informant. And Mr. Adolph Brown challenged the use of both the order under the Stored Communications Act pre-Carpenter, but he also challenged the affidavit based on this confidential informant who had basically given information to the government that Mr. Brown was known to be trafficking drugs from the Ohio border into Pennsylvania. So ultimately, this case comes to me and with a motion to suppress, and I deny the motion to suppress. And in that particular instance, there was some litigation around this Stored Communications Act, again, pre-Carpenter, but what really carried the day here was a very detailed affidavit of the FBI agent and information supplied by the confidential informant. Now, ultimately, Mr. Brown did go to trial. He was convicted. He's recently been sentenced. Mr. Kennedy, who was involved in the smash and grab in my neck of the woods, went to trial, was convicted, is now doing 155 months in a federal penitentiary. And in those instances, those cases are now closed and shut. You might wonder, well, what happened to Mr. Carpenter now that we have this landmark decision? Well, Mr. Carpenter's case has been remanded back to the Eastern District, well, first to the Sixth Circuit and then the Eastern District, but really there's been no action on the docket. But what I would suspect here is because the orders were initially signed, even if they could be found to be defective, the law enforcement people acted in good faith, and hence I don't see his hefty sentence of 100 years being overturned. But as we were talking last night, and I'm looking at Andy, as Andy's bio reflects, he spent many years as a magistrate judge in the federal system, and I thought for those of you who haven't been on this side of the fence, it might be interesting for you to hear how this all works and how it goes to the magistrate judge and how the magistrate judge weighs and then makes a decision.
Yeah, the way it works is
You look at it and you see whether it's your phone number, and otherwise you say,
well, yeah, there's mine or my friends, of course. No, the U.S. Attorney's Office will come in with an application. If it's merely an SCA application, Stored Communications Act, they don't need an agent. It's basically the AUSA is able to say why they have reasonable suspicion, and if there's reasonable suspicion, which is an extremely low standard, it would get signed. In our district, even before Carpenter, for prospective cell site information, even though we had two decisions, one of mine saying you need probable cause warrant for it, and one of the district judges saying, no, you don't, all the magistrate judges in our district sort of got together and convinced the U.S. Attorney's Office that at least for prospective cell site information, they would do it on a warrant trying to establish probable cause. So, of course, it always had this footnote saying, well, we don't think we have to go so far as to show probable cause, citing the other opinion from the district, because we want you all to be happy, we'll do it here, sort of thing. So in our district, prospectively, they had to show probable cause. For retroactive or retrospective historical cell site information, there was a split. And so if they came on a duty day where I was on, I required probable cause. Probably 2/3 of the Southern District magistrate judges required probable cause for that. Several magistrate judges under the third-party doctrine said no, they don't. The third-party doctrine, which came out of toll records for telephone calls and banking records, said if the information is in a third party, there is no right to privacy in it, and the government could get it from that third party or from you without needing to show probable cause and satisfy the Fourth Amendment. What I thought was interesting about Carpenter is that the Supreme Court did not overrule the third-party doctrine. They created this narrow exception, and Chief Justice Roberts was very careful to say, in essence, this is a special rule for cell site information, and we'll worry about the third-party doctrine and other doctrines implicated here, perhaps in other cases.
But that's what makes this case so, again, kind of, from my perspective, so problematic. You know, this whole third-party doctrine is where all the privacy rights advocates had, you know, pinned all their hopes on. Judge Peck mentioned this, but we're talking about reasonable expectations of privacy. And so if the information's in the possession of a third party already, you don't have a reasonable expectation of privacy anymore under the Fourth Amendment to keep that out because someone else has already got the data. And so the Chief Justice in this majority opinion says, okay, if they have 6 or 7 or more days of historical data, sort of going back to the Jones case where they inserted this GPS. It's a continuous tracking, and cell phones have our whole life history, and so you have a reasonable expectation of privacy for this 6 or 7 or more days of historical data. Well, where do we get this 6 or 7 more days? I mean, why not 1 day? And then the other part that's kind of problematic about this opinion is, you know, right now, the government can get a complete cell phone dump from the tower, all its contents. And the Chief Justice says, oh, we're not discussing that. For now, that's perfectly fine. And we're worried about government intrusion. A whole cell phone dump from the tower is okay, but 6 or 7 days is problematic. The opinion was very inconsistent to me, and that's why, I guess, why I have problems with it.
And we're going to have more time to cover it. Ed McAndrew, who's sitting over here, is going to be joining us at 5 o'clock. From Carpenter to the GDPR, data privacy. We'll have a full discussion on that. If you find the diversity topic of interest, please join Justice Kennedy and me at 2:20 in a few moments, where we'll be doing access to justice, and these issues come up. But importantly, we've covered diversity, we've covered data privacy, we've covered ephemeral apps. Most importantly, on behalf of the 900 Relativity employees, our 29 cloud partners across the world with Relativity One, and the many on-premises partners, thank you for spending an hour of your day. The score is Cubs 1, Brewers 1. Thanks for being here. We'll see you next year.